In everyday language, perfection generally refers to the state of being free from any flaws or defects. But in law, perfection refers to the completion of additional steps needed to make a security interest enforceable against third parties. The Eighth Circuit considered whether the parties had perfected security interests in cattle and whose interest had first priority in Kunkel v. Sprague National Bank. John and Dorothy Morken granted Sprague National Bank a security interest in their inventory and farm products, among other collateral for loans. Sprague perfected its interest by filing a financing statement with the Kansas Secretary of State. In 5 subsequent transactions, John purchased interests in cattle from Hoxie Feeders. Hoxie financed all the cattle purchases and retained a purchase money security interest, or PMSI, in the cattle. Instead of filing, Hoxie perfected by taking possession of the cattle under feedlot agreements with John. Not long after that, the Morkens declared bankruptcy, and Hoxie sold the cattle for slaughter. The Morkens bankruptcy trustee, Philip Kunkel, sued to determine whether Sprague or Hoxie was entitled to the proceeds from the sale. The bankruptcy court entered summary judgment for Hoxie, finding that Hoxie had superpriority over Sprague. Superpriority means that Hoxie had priority, even though Sprague perfected its interest in the cattle first. Sprague appealed to the federal district court, which affirmed the summary judgment on superpriority grounds. As an alternative, the district court found that Sprague never had a perfected security interest because John had insufficient rights in the cattle for a security interest to attach. Sprague appealed to the Eighth Circuit.